Good morning, everybody. Thank you for joining us today. This is the top 10 ways to stay out of court, sponsored by the Workforce Development Board of Riverside County. My name is Stephanie, and I'm the marketing director here at California Employers Association. Before we get into today's training, as everybody's getting settled in, I have a couple of details to go over with you. As you can see, your audio will be muted throughout the presentation, but there will be lots of opportunities to engage during the training. If you have any questions about the content, please put them in the chat box at any time. We're going to pause about halfway through the presentation to go over anything that was submitted, and we're also going to stay on at the very end to wrap up any additional questions that come through. So put them in the chat box whenever you think of them, and we will get to them. The handouts will be dropped into the chat box shortly. You also should have received them in an email. Once you see the file in the chat, you can click it to download. This webinar is being recorded, and the team at Riverside County will reach out whenever it's available for playback. We're also going to invite you to share your feedback at the end of today's training by participating in a brief survey. It's only 5 questions. It'll take you less than 2 minutes, I promise. It's very short, but we love getting your feedback. It helps us make sure that these webinars are giving you the information you need and to make things better as we move forward. Again, our training today is brought to you by Riverside County. And today we're joined by Jason Tang, the development manager, to share a little bit more about the resources available to employers like you.
All right, thank you so much, Stephanie, and welcome everyone to our webinar today. So in workforce development, our mission is to not only help individuals prepare for and thrive in the job market today, but also to build strong relationships with our industry partners, with our programs, resources, and services, and to provide businesses with the information that they need in the ever-changing landscape when it comes to labor laws. And so, as exemplified by the title of today's webinar, Top 10 Ways Employers Can Stay Out of Court. So pat yourself on the back for showing up today because it is important. And did you know that California businesses are 40% more likely to face employee lawsuits compared to the national average? So it's a really important topic, and we're grateful that CEA is here, California Employers Association. And before we kick off the webinar, I just want to remind everyone of our free Riverside County HR hotline that is run by our amazing partners here at the CEA. You can call to get any of your questions answered. They have experts on hand ready to answer any of those HR questions that you might have. It's a fantastic service. It's free for all of you. It can keep you out of trouble. So please jot this number down. Keep it handy for whenever that HR question pops up in your head. And we are always here at Riverside County to help you as well with any of your workforce needs. So thank you for being here, and Stephanie will send it back to you.
All right, thank you. Yes, please make sure you guys write down this hotline number. We are here Monday through Friday, 8 to 5, ready to answer anything. Any questions, no matter how big or small, give us a call. We will help you out. All right, so now it's time to start the meat of the presentation. I'm going to pass this over to Juliana Gabriel, our Senior HR Compliance Director. Take it away, Juliana.
Thank you, Stephanie. Thank you, Jason, and welcome to our Riverside County employers. We are excited to have you join us today. I want to give a reminder before we start that this presentation today, although we're talking about top 10 ways to stay out of court, is for educational purposes only and should not be relied upon as legal advice. So CEA is not a law firm, and we cannot give you legal advice when you're calling into the hotline or on these trainings, but we are more than happy to answer your general questions about the content or clarification that you need. So as Stephanie mentioned, you can go ahead and put those questions in the chat box. We'll be monitoring those throughout to make it as practical as possible for you today. Now, who is California Employers Association, or CEA? For those of you joining us for the first time, we are an HR consulting company, and we have members located throughout the state of California and beyond. And our goal is to provide you peace of mind with exceptional HR compliance solutions. So just to give you a little idea of what it's like to be a CA member, if you find that you need some additional support beyond that wonderful hotline provided by Riverside County, you could join us and get access to our extensive library of sample forms, policies, and toolkits, which we're constantly keeping up to date with all of California's changing requirements. And we can also help you out with projects. So if you need us to work on a customized employee handbook for you, provide some training for your staff, come and conduct an HR audit, assist you with a workplace investigation, we can help you out with all of those types of services. So we have our website listed here, as well as our main phone number. You can call in directly to us with any questions about membership or CEA services. All right, so what is on our agenda today? We have a lot to talk about. I have to tell you that Top 10 Ways is one of my favorite trainings to give. We've come up with this list over the years at CEA. Our subject matter experts have put it together, involving really the key or crucial areas of California law that you want to pay attention to and kind of give you the most bang for your buck, so to speak, in ensuring that you're running in a compliant manner and avoiding the most claims and issues. So we are going to look at the employment relationship from start to finish. So how you really get off on the right foot when it comes time to end that employment relationship, how you do that in a compliant manner. We're also going to talk about the importance of your employee handbook and why you want to make sure you're keeping that up to date and compliant. We'll go over what policies you're required to have in California, and then also the very highly recommended policies you want to make sure are in there. We are, of course, going to spend a lot of time on wage and hour issues. This is maybe one of the biggest ones in California because it can lead to so many expensive penalties and claims. These are usually the biggest type of lawsuits. We see a lot of class actions in this area. So you want to make sure you have a really strong foundation on understanding meal and rest breaks, timekeeping, overtime requirements, and how to properly classify your employees in the first place. Right after wage and hour, I would say the next biggest area where we see a lot of litigation is harassment and discrimination issues. So we're going to talk about how do you really proactively address these types of potential issues before they do turn into a claim or complaint. All right, so let's start with top tip number 10. You want to ensure that you have strong hiring practices, that you're getting off on the right foot with your new hires. And at CEA, we have a phrase known as hire slow, fire fast. We'll talk about fire fast later in the training. But what we mean by hire slow is you really want to be thoughtful before you even go and post that job posting on LinkedIn or Indeed about what it is you're looking for. So if it's a new position, write up a job description on what are going to be the essential functions of that position, what are the qualifications, and then think about, are you looking for someone to be exempt or non-exempt, part-time, full-time, hybrid, on-site? Think about all of those things, because if you are thoughtful up front and then you put it out there with your job posting, you're going to be much more likely to attract a candidate that really truly meets those qualifications that you're looking for. Another important thing to remember in California is we have some very specific restrictions when it comes to the hiring process and what we're able to consider. There's restrictions on considering salary history, criminal history. We'll talk about that a little bit more in just a minute. But these are some restrictions that we just don't see in other states that we have to be aware of in California. We also at CEA really like to preach that new hire orientations set the tone for the entire employment relationship. And you do want to make sure you're getting that person off on the right foot where they feel like they're really connected to your organization. They have good relationships with their coworkers. Because if we don't do that, sometimes we miss the mark and that person just ends up not being a really good hire, or they become disgruntled over time. So that could be something as simple as taking the new person around the office and introducing them to their coworkers. So they start to learn the names and faces. They feel more comfortable asking questions. At CEA, what we do is we have everyone set up Zoom meetings. It's a little bit easier to do it virtually. So think about how you're going to get that person really engaged and feeling like they're part of the team. Another thing we really recommend with your new hires is coming up with written goals for 30, 60, and 90 days of employment. This can be so crucial because then you can have your supervisor or manager follow up with them and actually give performance reviews at those checkpoints. And this can seem like kind of a lot, but really it's going to ensure that that person really is learning how to operate your organization, that they're staying on track, and it gives you an opportunity to identify any issues early on. And then in California, we also have a laundry list of required hiring documents. So in addition to the I-9 and tax forms like the W-4 and DE-4, we also have a number of required notices from our state agencies like the Civil Rights Department and the EDD. So you want to make sure you have all of those documents ready to go when you are onboarding a new hire. All right, so let's talk about those potential interview landmines that might land you in court. And you want to make sure you're training really everybody involved in the hiring process. So if you have managers that are, or supervisors that are involved in interviewing, make sure that they are up to date on this. So really, generally, we should not be asking questions that involve protected classifications. So involving someone's race, religion, gender identity, we have around 30 different protected classes in California. And I think most people know this, that it's not a good idea to ask about these types of questions because we're opening the door to potential discrimination claims that an applicant might say, well, you didn't hire me because I fell into one of those protected classes. But where I see this come up a little more inadvertently, or you might not realize, or it might not dawn on the person, questions about age. They might say, oh, you graduated the same school as me. What year was that? How old are you? Well, now we've kind of opened the door maybe to a potential age discrimination claim if we don't end up hiring that person, that they can make an argument that it was based on their age. Same thing with family status. And usually the interviewer is just trying to maybe connect with the person. Are you married? Do you have kids? But we have seen cases where someone's brought a gender discrimination claim saying, well, because I'm a mother, you assume that I'm going to have childcare obligations that are going to interfere with the job. And you asked about that in the interview. So be careful with that. In California, we are also restricted from asking about salary history. So we should not ever ask someone what they earned in a previous role, what their benefits package looked like. That would be off limits under almost all circumstances. What we are allowed to ask about is salary expectations. So we can ask, what would you like to earn in this role, or what are you expecting to earn? Another big area is restrictions on criminal history. So we cannot, if we have 5 or more employees, we cannot inquire into criminal history until after we've extended a conditional offer of employment. So once we've extended that contingent employment offer, we can then ask someone if they've been convicted of a crime. We can conduct a background check. But even if something comes up in that background check, we still aren't necessarily able to deny the position. So we have to be able to show that that criminal history would have a direct and adverse relationship with the specific job duties. So let me give you an example of that. If you're hiring for a driver position and it comes up that that person has multiple recent DUIs, you could probably make a pretty strong argument that that would create a safety issue. But if you're hiring for a cashier position, it becomes harder to make that argument. And you always have to make an individualized assessment, have to analyze this on a case-by-case basis. And there's also required notices that you have to give and allow the applicant to challenge or provide other factors that you should consider. The Civil Rights Department has a lot of great resources on this. You can also call into us on the hotline if you need assistance with that, because it really is an involved area. Now, what we do want to focus on is questions about the job and how well the applicant can perform it. And that's why if you have a strong job description already drafted, you can really keep that interview focused to that. Now, if you do need all of the new hire paperwork that I was referring to, we do have it available for purchase on CEA store at employers.org. If you're a CEA member, you can refer to our HR forms with our new hire and orientation checklist. All right, tip number 9 is you want to make sure you are aware of California's many leave laws. So in California, we have more than 20 different leave laws that may apply to an employer. And each leave law works a little bit differently. So for some employees to be eligible, they may have to complete a length of service requirement. We see that with family and medical leave. But other leaves of absence, they're eligible from day one, like pregnancy disability leave. So they all operate a little bit differently. Now, not all leave laws may apply to your business. They're going to be based on your employee headcount. So there are some leave laws that apply to all employers, regardless of size. But a lot of them kick in if you have 5 or more employees. Then we're going to have pregnancy disability, California Family Rights Act, bereavement, and others. And then some more kick in if you have 25 or more employees and 50 or more employees. So the larger the employer you are, and we're talking headcount, both in and outside of California, we are looking at total number of employees for your company. So the larger you are, the more leaves that are going to apply. Now, today we're going to focus on just one leave that's really important and applies to everyone, and that is mandatory paid sick leave. And employees can bring claims against an employer if they deny mandatory paid sick leave, retaliate against an employee for using it, or interfere with that right. So it's really important that we understand what we need to provide in California. So the minimum that we need to give our employees is 5 days or 40 hours each year. And that was expanded just within the last couple of years. It used to be 3 days or 24 hours. So make sure you go back to your handbook. If you haven't updated it in a while, you want to make sure that it accurately states that it's the 5 days or 40 hours. And your handbook is a really good place to refer to because that is also going to give us information on how you provide paid sick leave at your company, because you have a couple different options. So some employers choose to do the accrual, where someone is earning 1 hour of paid sick leave for every 30 hours worked. And that's going to keep accruing up to 80 hours. That's the cap, 80 hours or 10 days, although we could limit someone to only using or accessing 40 of those hours in a year. The other approach is the lump sum or front load method. It's a little easier to administer. That's where you are just front loading the 5 days or 40 hours at the beginning of the year. The employee may use it or not, and then it resets or refreshes the bank on the same day each year. So for example, on January 1st, if that's the date you've selected. Now for new hires, you can require a new hire to wait until 90 days to actually use paid sick leave, as long as you put that in your policy. So that is something you can do as the employer. Now in California, you do not have to pay out sick leave, remaining sick leave at the time of termination. This is different than vacation. Vacation is viewed as wages, so we do have to pay that out at termination. But if you have a separate sick leave policy, you don't have to do that. Now, the one exception to that is if you combine vacation and sick into one paid time off or PTO program, then everything does get paid out at the time of termination. So be aware of that if you have a PTO policy. And then also there are some local ordinances out there where you may have employees working that provide even some additional paid sick leave protections and requirements. So some examples of that would be Los Angeles, San Diego. So if you have employees working, especially in larger metropolitan areas, make sure you check on those paid sick leave local ordinances. All right, top tip number 8. You want to ensure that your exempt employees are really properly classified as exempt. So this is going to kick off our wage and hour discussion, and we are going to spend quite a bit of time on wage and hour because, as I mentioned, these are some of the most expensive lawsuits in California. So we want to remember with our exempt employees, they have to pass 2 tests to be properly classified as exempt. They have a duties test as well as a salary minimum. We do not have these tests for non-exempt employees. You can classify anybody you want as a non-exempt hourly employee, but to be exempt, we have to overcome those hurdles. So for the salary test, we'll start with that. What's required is that you pay that person 2 times the state's minimum wage. So every time the minimum wage goes up, that exempt salary amount goes up. So for 2025, you're looking at $68,640 per year. And the first question we always get is, well, what if we have an exempt person that's working more part-time? Can we prorate that amount? And the answer is no, that's an absolute minimum. Otherwise, you'd want to reclassify that person to non-exempt and start paying them by the hour. So we typically cannot make deductions from an exempt employee's salary. They are paid a flat salary each week that they are performing work for us. Now, there are some special salary amounts for certain commissioned employees, computer professionals, and physicians. So if you have those exempt professionals in your business, make sure you refer to those specific salary amounts. You can also call into the hotline. We'd be happy to help you with that. As well now as certain fast food and healthcare workers, because they have their own minimum wage requirements. And it's been interpreted that their exempt salary is tied to those minimum wages. So for fast food workers, we might know that for some that work at large chains, they're earning $20 an hour. So they have a higher exempt salary amount. Now, the good news is if someone passes both the duties and salary test, we don't have to worry about a lot of wage and hour requirements. So we don't have to worry about overtime, meal and rest breaks. They don't have to track their time. That's generally not going to apply. So it's easier to deal with from a compliance perspective. Now, the second component is the duties test for what's known as these white collar exempt categories. And so someone would need to fall into at least one of these buckets to be properly classified as exempt, that they're engaged in these types of duties more than 50% of the time. And for all of these exemptions, they have to be customarily and regularly exercising discretion and independent judgment, meaning they operate with a lot of autonomy. They are making decisions. We're not micromanaging these folks. So the executive exemption is someone whose primary duty is managing 2 or more full-time employees in a business or permanent unit. So be careful, not all supervisors will qualify because, again, they have to be engaged in these types of duties more than 50% of the time. So they need to be involved in hiring and firing, delegating work, managing performance, dealing with employee grievances. Those are the types of things that would qualify for this executive exemption. Administrative is someone whose work directly relates to management policies or general business operations. So this is someone that is reporting to an executive or a sole proprietor. They're doing really high level work, working on business operations or overseeing a department, and they're doing office, non-manual work. So some of the folks that have been considered to be classified under this exemption, in certain cases, certain HR professionals, tax advisors, data analytics would sometimes fall under the administrative. And then we have the professional. So this is someone that is in a field of science or learning, and this is typically a Bachelor of Science or higher that they're using in their job, or they have a specific license or advanced degree that's spelled out under the law. So some examples of that would be attorneys, architects, engineers, teachers. There's a specific list of those folks that would qualify for that. You want to make sure your exempt employees are properly classified, because if we don't get that right, that means that this person could turn around and come after us for meal and rest break violations, unpaid overtime, etc. So we really do want to get this right. All right, tip number 7, and this one I wish we had like a big disco ball or flashing lights, because it's probably one of the most important, and that is you want to make sure that for your non-exempt employees, your hourly employees, that you are following all of the wage and hour rules. And this is where we see some of the most expensive lawsuits, class actions. So again, we want to make sure we're complying with this. So for our non-exempt employees, they are paid by the hour for work that they are performing for us. And in California, we really have no such thing as off-the-clock work. There was a big case a few years ago known as the Starbucks versus Troaster case. And basically what was happening in that case is the employee would clock out at the end of the day, and then they would clean up a little bit, lock up the store. It'd maybe be a few minutes of time that was off the clock each day. And the court basically said that adds up over time, and that's off the clock work that you're not paying that employee. We don't have the same de minimis doctrine under federal law that would allow for that. And so you owe that employee all of these penalties for getting that wrong for so long. So you want to make sure you have really accurate timekeeping systems. If you do, digital punch in and punch out systems, or on someone's cell phone, that can be really great to really get it down to the minute. If you use timesheets, that's still lawful, but I would just caution, make sure you really train your employees on that. I've seen plaintiffs' attorneys scrutinize if they see everybody have the same exact time entries that line up with the shift times each day. So 8 to 5, 8 to 5, 8 to 5. I've seen them say, is that really realistic? It's probably not the case that they are clocking in and out exactly at those times every single day. So what I'd recommend, if you use timesheets, put a big digital clock up at your work site, and then train your employees. You need to write your time down to the minute. So if it's 7:59 or if it's 7:58, write that down that way. So we want to, again, ensure that we have good timekeeping practices. And then we also need to follow our breaks and lunch requirements. We'll talk about that, overtime, etc. Now, also, you want to make sure you know which IWC wage order applies to your employees. So there's wage orders by industry and occupation, and they're going to have our specific wage and hour rules for your business. And you actually want to make sure that you have this wage order printed up in your workplace. It does have multiple pages, so we usually recommend putting it on a 3-ring binder and hanging it up next to your labor law poster, for example. So you can Google and download your wage order. If you need help with that, again, you can call the hotline and we can refer you to how you can find your wage order. All right, so for our non-exempt employees, we have to be sure that we are paying the minimum wage. So the state's minimum wage is currently $16.50 an hour for employers regardless of size. But of course, it's not quite that simple in California. We now have these industry-specific wage requirements, as I mentioned. So for fast food workers working at a chain with over 60 locations nationally, they're at $20 an hour. Healthcare workers, most healthcare workers now fall under their own wage requirements that are currently anywhere between $18 and $23 an hour, depending on the type of facility. And those are actually scheduled to increase July 1. So if you're in healthcare, make sure you're ready for those mid-year increases. We also, for all employers to pay attention to, we have over 40 different local minimum wage ordinances that may apply. So if you're sending employees out of your area to different cities or counties, you want to make sure you're checking on that, because the local minimum wage is based on where the employee is physically working that day. So if you have remote employees, you need to determine, do they fall under a local minimum wage? If you're sending someone to a client site or a conference, you want to check on that. So for example, San Diego's local minimum wage is at $17.25 an hour. That's more than the $16.50. So be careful with that. We do have a great fact sheet for you at this bit.ly link here. You can put that into your browser and it lists all of the current local minimum wages. A lot of these increase January 1 each year, but there's also a good handful that increase July 1. So be on the lookout again for those mid-year wage increases that are coming up in just a couple months. All right, rest breaks. What do we need to provide to our non-exempt employees? Well, remember, we must authorize and permit an employee to take 10 minutes net rest time for every 4 hours worked or a major fraction thereof. So if someone is working 3.5 hours or more, they're going to be entitled to at least one rest break. Once they get between 6 and 10 hours, we're looking at 2 rest breaks. So for a normal 8-hour shift, you need to make sure there's 2 rest breaks. And as we're going to learn, they would be entitled to 1 meal period for an 8-hour shift. Now, once we go 10 to 14 hours, then that 3rd rest break kicks in. Now, the rest period needs to be in the middle of a work period. So we are not allowed to tack it on to the meal break, and we're not allowed to put it at the very beginning of the day so that someone could come in late, or at the very end of the day so they could leave early. We're not allowed to do that. Rest periods are different from the meal period in that they are paid time. So typically your employees shouldn't be clocking in and out for the rest periods. But it is a really good idea to document somewhere that that employee received all of the rest periods. I would have them acknowledge that either on a daily basis in writing or per pay period. That can be some really good evidence. Again, if you do end up with a claim or you're in court and someone says, I never received any of the rest breaks I was entitled to. Well, then your attorney can show, well, every single day or every pay period, you certified that you received all your rest breaks and you never told a supervisor that you didn't. So that can really help be a good defense. And then also just remember, you cannot restrict employees from leaving the premises. So for both meal and rest breaks, they are allowed to leave the premises. It's completely 100% their own personal time. Now, if we fail to provide a sufficient rest break, or we've interfered with that rest break in some way, we've given them work to do, we are going to owe them 1 hour of premium pay at an employee's regular rate of pay for all rest break violations in a workday. So make sure that if there is an issue with a meal or rest break, that you are paying that premium pay and that it's reflected on your wage statements. All right, what about meal breaks? So for meal breaks, we need to permit a minimum 30-minute uninterrupted meal break if the employee works more than 5 hours in a day. So less than 5 hours or 5 hours or less, no meal break is owed. Once we go over 5 hours and a minute, we owe that meal break. And then if they work over 10, we owe a second meal break. Now, meal breaks are unpaid. So in this case, they are clocking in and out, and we should see that full 30 minutes on their time cards. Now, we do have strict timing requirements with the meal break. That's a little bit different than the rest break. So the meal break must begin before the end of the 5th hour of work. So what that means is your employee should be clocking out to begin their meal break no later than 4 hours and 59 minutes into their shift. If they're just a minute late, we're going to owe that premium pay penalty if it was the employer's fault for that. So what we'd recommend is that you are scheduling those meal breaks maybe at the 4-hour mark, 4 hour and 30-minute mark. I probably wouldn't get too much further along than that, because then you are risking that they might get tied up with work, and then you're going to potentially owe that premium pay if they're late. So no time clock rounding when it comes to meal breaks. So even if it's 28 minutes and you're thinking, well, that's pretty close to 30, you're going to owe that premium pay. So again, it needs to be a full 30 minutes or more. All right, what about overtime requirements? So in California, we have some special rules when it comes to overtime. We have daily overtime, we have double time in some cases, and then we have this special rule when someone's working 7 consecutive days in a work week. So let me unpack that all for you. Under most wage orders, this is how overtime works. You need to pay time and a half, someone's regular rate of pay. If someone's working over 8 hours in a work day, that's the daily overtime. Over 40 hours in a work week, that's weekly overtime. And then for the first 8 hours worked on that 7th consecutive day in a work week. And this is why it's so important to see how you define work week at your company. It's always going to be a 7-day period. The default is Sunday through Saturday. And so it would always be Saturday that you would be looking at in that case to see if they've worked that 7th day in a row. But if your work week is defined as Monday through Sunday, then it would always be Sunday that you're looking at to see if they worked that 7th day in a row in a work week. So it depends on how you define your work week. Now, double time kicks in if someone's working over 12 hours in a workday. And if they go beyond that 8 hours on that 7th consecutive day in the work week, then it kicks into double time. Now, really, really important, crucial point here is overtime pay is based on someone's regular rate of pay, not their base hourly rate. So what do I mean by that? You might have someone that earns minimum wage, $16.50 an hour. That's their base hourly rate. But if you give them additional forms of compensation, commissions, piece rate pay, non-discretionary bonuses, that is going to mean that their regular rate of pay is higher than their base hourly rate. Maybe when you factor in the commissions per hour, really the person's earning the equivalent of $18 an hour instead of $16.50. So it would be that $18 an hour if that was their regular rate of pay that you would use to calculate overtime. If you're using the base hourly rate, you are not going to be sufficiently paying overtime and you are risking penalties per employee, per pay period. It can go back in a lot of cases up to 4 years. So you can see how quickly things spiral and get very expensive in the world of wage and hour if we're not doing it correctly. So what you want to do is make sure that if you do have any of those additional forms of compensation at your business beyond the base hourly rate, that you take a look and make sure that your payroll provider is taking those into account and calculating the regular rate of pay properly. If you have a lot of different additional forms of compensation, it might even be a good idea to get some legal counsel and have them review your calculation. All right, and then I also want to talk about PAGA reform that happened last year. PAGA stands for the Private Attorneys General Act. And what PAGA is, it's this law that allows employees to basically step into the shoes of the California Labor Commissioner and go after employers for wage and hour violations, not only on behalf of themselves, but on behalf of other employees. So they're similar to class action lawsuits, but not quite the same. It's going after penalties that are paid out to employees. Some of it goes to the state, some of it goes to plaintiffs' attorneys. And there's been a lot of scrutiny over the years with PAGA. A lot of business groups have basically said there's kind of an unfairness to PAGA, that a lot of employers are trying to do the right thing and they get hit with multiple PAGA lawsuits and it's so expensive. And so there was some reform to PAGA last year. They made it a little more employee friendly now, or employer friendly now, which is good news. And I really want to call your attention to one specific component of that, and that is new opportunities for employers to reduce their penalties if they're hit with a PAGA lawsuit. So in some cases, you could reduce your penalties by up to 85%, which is huge. If you can demonstrate that you've been taking reasonable steps at your business to comply with wage and hour laws. And the legislature has actually spelled out what those reasonable steps are that they want to see. So they want to see that employers are conducting periodic payroll audits and taking action in response to results. So for example, taking a look at your meal and rest breaks. Are we providing compliant meal and rest breaks? When we're not, are we paying that premium pay penalty? Are we calculating the regular rate of pay and overtime properly? Do we have all of the required information on our wage statements? All of those types of things they'd want to see that you're auditing and then taking action and correcting where you find errors. They also want to see that you are distributing lawful written policies to your employees. So keep that handbook up to date. Have your employees acknowledge, maybe on an annual basis, your meal and rest break policies, overtime, timekeeping, really crucial. They also said training supervisors on wage and hour rules. So they didn't go so far as to make it a mandate, but they're basically saying, we want to see that your supervisors are actually getting formal wage and hour training. I think for most businesses, it probably has happened more informally, just kind of learned on the job. But now there's going to be this push to do it more formally. and then taking corrective actions for supervisors who are not following your policies. So let's say you have a supervisor that's interrupting someone during their meal break with work-related questions. Well, now that's a deficient meal break. So we need to coach that supervisor or maybe discipline that supervisor, even if it continues to be a problem, and keep a record of that. Now, if you do need some assistance in this area, CEA does offer a wage and hour audit package to help you through your own self-audit. And then also it includes a recorded wage and hour training for your supervisors so that you can provide that more formalized training that will put you in a good position to show that you're operating in good faith here. All right, so we've reached kind of the halfway mark. We've already gotten through a lot of information. I wanted to see, Steph, if there's any outstanding questions that I can help answer.
We had a couple questions coming through the chat box that Kim has graciously answered for us. So nothing outstanding. We had a question about a written list of all the required hiring documents, and Kim put a link to the new hire packet in the chat box. So if you click over to that link, you'll be able to see that list. And then we had some additional questions about the salaried exempt. The question was, if a salaried exempt therapist works by providing client sessions, if they take one day off and submitted unpaid time off, no sick leave or vacation balances left, can they adjust their pay for their work that week, reducing it since they did not complete their required work for one day during the week? And the answer for that one was, deductions are permitted only for full day absences for personal reasons, not including sick leave or vacation, if the employee did not perform any work during that day.
That is exactly right. So thank you very much, Kim, for getting to those in the chat box for me. Yes, exempt is really tricky because it's very rare when we can make deductions. When we can, it's very specific and it's limited to full day deductions, as Kim mentioned, if someone's out for a personal reason. And if someone only worked part of the day, even just sending an email that day, we can't make any deductions to their salary in that case. So as a general rule of thumb, you want to kind of assume if someone performs any work in the work week, they're generally going to earn their full salary for that week. All right, another area, and I promise this is the last wage and hour issue that we're going to go over, but as I mentioned, it's so important. Number 6, you want to avoid misclassification of independent contractors. So just like with our exempt employees, we need to make sure to get it right. We need to make sure to get it right if we're hiring someone as an independent contractor or 1099 worker. In California, a lot of out-of-state employers are very surprised to learn how difficult it is to properly classify someone this way. They have to meet what's known as a rigorous ABC test, meaning that they are A, free from the control and direction of the hirer. So they are really determining how they perform the work, when they perform the work. They have a lot of autonomy. B, they're performing work that's outside the usual course of the hiring entity's business. This is where most people fail the test. So as an example, if you're an accounting firm and you hire someone to do some reception and billing work for you, that's probably going to be viewed as in the course of your business. Now, if you're hiring someone to come do interior design work for your office space, that's going to be very clearly outside the course of providing accounting services. But you can see how that's tricky, and there could be a lot of gray area in between. And then C, customarily engaged in a trade, occupation, or business of the same nature as the work performed, meaning that they're really holding themselves out as their own business. They might even have other clients that they're servicing, that they don't look like they are truly just your employee. This test is so hard to satisfy, and there's so many nuanced exceptions to it that we just recommend before you classify anyone as an independent contractor, you consult legal counsel, have them also draft up the contract for you while you're at it. That's a really good idea. Because again, even if the person agreed to be your independent contractor, if they're not properly classified, they can come back after you for meal rest break violations, overtime, etc. So again, we want to get this right. Also be aware there was a new law last year known as SB 988, and it requires you to have a written contract if you're hiring an independent contractor for $250 or more in services for these types of services listed here. So some examples are marketing, graphic design, HR, photography. Then you have to have a written contract that has certain components to it. Again, at CEA, we would recommend that for any independent contractor agreement, you get that contract in writing, just so it's really clear what the scope of the agreement is. And if there's a dispute, you can turn to that contract. All right, tip number 5, you want to make sure that you are properly insuring your business in California. Sometimes we just cannot prevent a claim or complaint from happening. That's just the reality of operating in California. It's pretty easy to file a lawsuit, and sometimes it takes time and money to defend yourself and to show that it's frivolous. You typically would have to hire an attorney to defend that for you and go through the discovery process. So we can put ourselves in the best position possible, but it's not always avoidable. So, really important that you have employment practices liability insurance and you understand the scope of that insurance. That can protect you if you are, worst case scenario, hit with a discrimination or harassment lawsuit, wrongful term, wage and hour claims if your insurance covers that. And that can include current employees, but also former employees suing you or applicants. And it's just like, think about it, just like driving a car and you have insurance. You might have to pay that deductible, but it protects you from it getting really out of control and really financially harming your business, or in some worst case scenarios, putting it under. So, really important that you have that, you understand the scope of it. Another big one in California that you by law have to have is workers' compensation insurance. And how this works is if someone is injured or becomes ill in the course of their job, it's viewed as really a no fault insurance program where they can't come after you directly, the company. It would go through the workers' comp process under most circumstances where they could get wage replacement, help with their medical bills, etc. So make sure that you know your workers' comp carrier, that you're familiar with them. You should really be working in partnership with them if you do get a workers' comp claim, and also know the process. So anytime we have a workplace injury that goes beyond first aid care, we should be giving that workers' comp claim form for the employee to decide if they're going to file a workers' comp claim. So we do have those obligations. So make sure you understand that you have the paperwork ready to go. If you're a CEA member, we do have our workers' comp toolkit that walks you through the process and has all the forms that you need. If you're again, part of the hotline, you can call in to us for additional guidance if you get a workers' comp issue on your plate. All right, tip number 4, we want to make sure we are preventing and promptly correcting harassment. And as I mentioned, this is an area where you want to be proactive. So what do I mean by that? Well, number 1, we have our mandatory training requirements. If you have 5 or more employees, you need to provide mandatory harassment prevention training every 2 years. So your supervisors need to get 2 hours, and staff employees need to get 1 hour. And you also need to provide it upon new hire. So if you have a new hire, it's usually due within 6 months of hire, or if you're newly promoted supervisor, within 6 months of that promotion to get that second hour. This is important because if you get sued or someone brings a harassment complaint, it shows good faith on the part of the employer that you're keeping up with that mandatory harassment prevention training. It can be a really bad look to the Civil Rights Department or EEOC if you're not doing that. You also want to promptly investigate complaints of alleged harassment, discrimination, or retaliation. So this is actually required under the Fair Employment and Housing Act that the employer conducts a workplace investigation anytime they knew or should have known that harassment, discrimination, or retaliation might have been occurring. So we'll talk about that a little bit more in just a minute. And then make sure you're encouraging a communication culture in your workplace. And what we mean by that is you want to do some work to make sure that employees are comfortable coming forward when they have a concern or when they become disgruntled. I think a lot of employers kind of sometimes they feel it's easier if they just kind of turn a blind eye, they're not receiving any concerns or complaints. But it's actually a good thing when our employees feel comfortable going to HR or going to their supervisor, because it gives us an opportunity to try to correct or resolve it. Even if we can't resolve it entirely as the employee wants us to, a lot of the times, if they feel like we're taking it seriously, we're listening to them, that can make the difference between that person deciding, you know what, I'm going to go hire an attorney, or I'm going to go file with the EEOC or Civil Rights Department because no one cares. So make sure you really create that open communication culture, and also develop a policy that's really clear in outlining, if I need to bring a complaint, how do I do that? What are my confidentiality rights? How soon will this be addressed? In most cases, the Civil Rights Department recommends that if you get an allegation, for example, of harassment, that you should be starting that investigation within 48 hours. So it's not something that we should be sitting on for weeks on end. So potential investigation triggers with this new or should have known standard. So It might come to you that someone's bringing a formal complaint that they want you to investigate, but a lot of the times it plays out differently from that. Sometimes it's more informal, where an employee is maybe just venting to a supervisor and they say, I want to keep this off the record. Well, it's really important that your supervisors understand there really is no off the record complaints. Even if the employee doesn't want to move forward with an investigation, or they say, I'm retracting my complaint, the standard is once you knew or should have known it might have been happening, you have to escalate that, investigate, and look into it. Because remember, other employees could potentially be at risk as well. So we must investigate that under California law. Sometimes, though, it might not be in the form of a complaint. Maybe you observe, or the supervisor observes the conduct. So maybe they hear that someone's making jokes about race or jokes about religion that touches on a protected class. We need to make sure we're investigating, well, what was the extent of that conduct, and how are we going to make sure that that stops happening now, if it was happening? Another way that you might be informed is you get an administrative charge or lawsuit, one of those more worst case scenarios. This doesn't mean that you just put your hands up and do nothing about it because you've already been sued. There would still be that obligation to look into the issue and investigate what you could on it based on the information that you have. But that would be a case where I would involve legal counsel to get some legal strategy on the best way to go about that, given that there's a pending lawsuit and your actions might be used against you. So make sure you get some legal advice if that occurs. Other ways that you might trigger it for you, maybe you don't have a legal obligation where you meet that knew or should have known standard, but you just start to see unexplained changes in the workplace. You see that someone all of a sudden becomes withdrawn, or they're having an attendance issue, or morale is really down. That could be signs that something's going on there. It might be harassment. It could also just be bullying, where it's not based on protected class, but someone's getting targeted at work. Again, we want to make sure we're promptly addressing these types of issues so employees feel supported, and not that, oh, I need to go get an attorney to help me out in this type of situation. All right, tip number 3 is use effective discipline and documentation. So it's really important that you really view the relationship with the employee as ongoing in terms of coaching, performance management. We really shouldn't just leave someone, out to just kind of figure things out on their own. We're never really checking in with them. Even with our good employees also want some level of feedback with how they're doing. And so I see a lot of employers where they have personnel files and there's just kind of nothing in there beyond the hiring paperwork. And we really should have a robust personnel file that shows those coaching conversations, performance review, performance management, and particularly where we're having issues with that employee. We should be documenting that in real time. So we should be informing the employee of what the problem is. Where are they falling short on performance, or what policies are they violating? We shouldn't just wait for an annual performance review to inform them of all of that, because we're not going to have a good, effective employment relationship that way. And we're also not giving them an opportunity to try to improve. Detail any potential consequences. Explain to them how you're going to help support them, or questions you're going to answer to get them on track. And then make sure you get their signature. And the reason this is so important is, even though in California, most employees are at will, meaning that we could fire them for any lawful reason without advance notice, it's really easy to claim that it was for an unlawful reason, that it was because I filed a complaint, or it was because I requested a protected leave of absence. And the more documentation you have to show that it was legitimate, that there was performance issues there, or there was policy violations there, you're going to put yourself in a better position, that's going to be more defendable, and it's going to be harder to make those types of frivolous claims against the company. All right, tip number 2, we're almost there. Fire fast with no surprises. So I mentioned we were going to circle back to fire fast. What do we mean by that? So we don't mean that you're going to rush the process, that you're not going to have your paperwork because you just need to fire someone. That's not what we mean. You still want to make sure you have your ducks in a row and you feel prepared when it's time to fire someone. But it's also not recommended that once you know you're going to end that employment relationship, that you just sit on it forever and ever. We've had so many calls where the employer did just that. And then, yes, the employee did then request a leave of absence, or they did then file a complaint. And especially if you don't have good documentation in your file, it's going to look like you're potentially retaliating against that person. And it might create a messy situation for you where maybe your legal counsel tells you, you know what, it's really not recommended that you fire this person right now. And a lot of employees are savvy. Sometimes they sense when they're about to be terminated, and then they might try to create a messy issue like that. So when it's time to end that employment relationship, get your paperwork in order and be ready to do it swiftly and in a compliant manner. You want to make sure the process is quick and fair, and really there should be no surprises. Again, if you've been working with the employee, you've been informing them of their performance issues and where they're falling short or their policy violations. It should be pretty clear why that employment relationship is ending. It shouldn't come as a shock. And if they've done something really serious like fraud or harassment, maybe you don't have a long history of performance management with them, but it again shouldn't be a surprise because that's a very serious violation. So the big thing to get right is final pay at termination. This is really important because if you are late on giving that final paycheck, we have what's known as waiting time penalties in California. So that person could come after you for each day that that paycheck is late or insufficient, a day's worth of pay for up to 30 calendar days. That's where it maxes out. So it can get very expensive very quickly. Now, anytime someone is voluntarily quitting, resigning, and they give you more than 72 hours notice, so maybe they give you that typical 2 weeks notice or weeks notice, pay is going to be due on the last day of employment. Now, when they're quitting with less than 72 hours notice, you get 72 clock hours to provide that final paycheck. And notice I did not say business days or business hours, it's 72 clock hours. So you kind of have to be ready to go once you get that resignation. Now, for a resignation only, if the employee consents to payment by mail in writing and that you get their mailing address, then you can mail the final paycheck, and mailing, the date of mailing will be considered the date that it was paid. So that buys you a little bit of time if they're willing to agree to that. Now, for an involuntary termination, if you're terminating someone, laying them off as part of a group, pay is always due on the last day of employment. And we recommend it's when the words leave your mouth. You're letting them know that they've been terminated and you have that check ready to go. We've heard of situations where someone's terminated, they didn't have the check, and the employee left and walked out and then sued for waiting time penalties. Final pay also should be a live check. Even if you had a direct deposit agreement, our California Labor Commissioner views that any direct deposit agreement does not apply to the final paycheck, that you would have to get a separate agreement from that person for the final paycheck, and you would still have to meet these timing requirements. So direct deposit just kind of makes things messy, that we just recommend a live check if you can. All right, so best practices when you are terminating someone, if you can, have a witness present, a neutral witness, so that they can write down what went over at the termination meeting, what paperwork was provided. Even if the employee is voluntarily resigning, it's still important that you get a voluntary resignation form filled out so that it shows that they're the ones that ended the employment relationship, not you, and also when the final date was of their employment. We generally recommend conducting exit interviews with the employee, whether it's a resignation or termination. I mean, in some cases with a termination, you might just want to do it quickly and get that person out of there. But it can be good to do exit interviews, even if you're not ending on the best foot with that person. It can give you insightful feedback or insight into how other employees are viewing things at your company, and again, give you that opportunity to address issues. We recommend using a termination checklist signed off by both the employer and the employee, stating what each party received, what was owed, whether company equipment needs to be returned, and it will list all of the required notices and final pay that was provided. So you have documentation of that for their personnel file. Now, again, if you do need those termination forms, luckily there's far fewer than with new hire. You can access that on CEA store at employers.org. And again, if you're a CEA member, then you would already have access to those forms through our termination toolkit. All right, and the final tip, we finally made it. Make sure you're following and keeping your employee handbook updated. So this is going to be really your starting point for setting your expectations for your employees, but also ensuring uniformity and consistency with your management team. It gives a spot that all of our managers can refer to and then provide consistent information to our employees, for example, on what leave laws might apply or what are our timekeeping practices here. So it's really really important. And also, we want to make sure we're keeping that up to date. We recommend, at least on an annual basis, getting that updated, just because California laws change so quickly. There's new leave laws, wage and hour requirements, et cetera. So really important that you're taking a look at that at least every year is what we would recommend. And CEA can assist you with that if you do need assistance with your employee handbook. So what is required versus recommended? So required policies, you need to have a harassment prevention policy, lactation accommodation, so that has to do with pumping rights at work, and then certain leave policies we have to have. So for family and medical leave, FMLA if you have 50 or more employees, CFRA if you have 5 or more employees, that's the California version of family and medical leave, pregnancy disability leave policy, and under most circumstances, you need to have a paid sick leave policy. Now, what's recommended? There's, of course, a ton that are recommended. Think about how little that list is on the left. So you want to have your at-will statement. As we talked about, one of the things you want to do is distribute your wage and hour policies. So we should have our meal and rest break policy, timekeeping, overtime, and then some other really key ones, your attendance program. So explaining what's unexcused versus an excused absence, what's protected, what's not, employee conduct policies. Drugs and alcohol is another really important one. And if you want to be able to test your employees upon reasonable suspicion, as is allowed in California, you would want to make sure you have a reasonable suspicion testing policy as part of that. And then vacation is an important one too. If you decide to offer it, we have very specific rules in California when it comes to vacation. So there are strings attached to that. So for example, you can't have a use it or lose it policy. There's certain caps that are considered lawful or not. So make sure that you have a competent HR professional draft your vacation policy so that it's in compliance with California's wage and hour requirements. All right, so I know that was a lot of information to get through in an hour, but we did it. So thank you for staying with me. And Steph, I did want to open it up in case we do have some outstanding questions I can answer.
Yes, we've got one open one over here in the Q&A box. Someone asked, what if you terminate someone on a Wednesday, but are paying them through the end of the week, Friday? Do they need to be paid on the day that you tell them?
So usually that's okay. So Friday, you're paying them through Friday. And when was the person let go, on Wednesday?
Yes.
Yeah, so you're paying more than you have to in that case. So that should be okay. And it could be viewed as paying the waiting time penalties for being late on the Wednesday. So if you pay them more and you're more generous, then you're okay, as long as you're paying through the date that you're providing the paycheck on.
All right, lots of wage and hour questions. Does anybody have any other questions that you would like Juliana or Kim to answer? Go ahead and put them in the chat box or the Q&A box. We are watching them both. And while we wait for people to think on that, thank you everybody for joining us. This was a ton of information. And as you're rereading the notes and trying to remember everything that was said, make sure you have this hotline number written down. You can give it a call anytime. Our HR subject matter experts will be happy to answer your questions. All right. It looks like we had one more question come in the chat box. I think we might need a little bit more information. The question is, if an employee fired but did not give a reason, can they do this? So I think we need a little bit more explanation on what exactly you're referring to, please. Go ahead and put that in the chat box and then we'll be able to help you out with your answer. On the screen here, we've got a CEA membership slide. We've got extra support for those who would like it. We've got Associate, Premier, and Ultimate members. We have membership starting as low as $125 a month. And that would mean, in addition to the unlimited phone support you get with your hotline, you get extra HR fact sheets and forms that you can use. We have some hiring forms, we have some termination forms, we have all sorts of great things and toolkits that you could use throughout your employee's life cycle. All right, and for those of you looking for your HRCI training codes, Juliana popped those on the screen. I'm also going to put them in the chat box for you. For those looking for your HRCI credits, that is 704947. And for the SHRM codes, it is 25-3GPWG. So if you're looking for your continuing education credits, there they are. And I also want to highlight another upcoming training from Riverside. I'm going to pop the link to that in the chat box as well. On June 12th, there's a California Leaves of Absence webinar coming up. That is another very exciting topic because California has a lot more leaves of absences than other states. So make sure you register for that one. Come on over and we will get those questions answered. And the survey that I mentioned at the very beginning of the webinar is now on the screen. There's a QR code. You can pop a photo of that with your phone. Again, it's a very short 5-question survey. I promise it won't take you more than 2 minutes. We'd love getting your feedback. What kind of things would you like to see in future events? What did you absolutely love about this event? Juliana loves getting compliments, so if you can go ahead and throw those in there, those will be great. I'll make sure she gets them. Yeah, and that is it for today. So let's take a peek at the question box and chat box and see if we got anything else in there.
Okay, I think I see what this question is getting at. So someone is asking if you have an employee that's violated your attendance policy, but then you get a doctor's note stating that there was a medical reason why they are out. You do need to be careful with that. It may be considered a protected leave where they could use their paid sick leave time, or even if they've exhausted their paid sick leave time, you could be viewed as needing to reasonably accommodate that person through the ADA if you have 15 or more employees, and California's FEHA if you have just 5 or more employees. So yes, anytime it's a medical issue, and especially if they have a certification for that, we usually do not want to count those against the employee's attendance. So that would be another way to stay out of court in California.
All right, thank you so much, Juliana. And it looks like you covered all the questions that popped up today. So thank you everybody for joining us. Thank you, Jason, so much for having us. We look forward to seeing you guys again on June 12th. Have a wonderful rest of your day, everybody.